Thank you.
Jeffrey, it is fundamental that motion for rehearing is not properly utilized to allow counsel to express personal displeasure with the court's conclusion. That is admittedly a clear violation of the rules of appellate procedure. Suffice it to say that in our earlier opinion, we concluded that your motion for rehearing did just that. In fact, you indicated clearly in paragraph 2, quote, "I cannot overcome my indignation engendered by this honorable court's per curiam affirmance of the lower court's order." We believed that your motion for rehearing was such a flagrant violation of the rules. We felt compelled to issue an order to show cause, both to give you an opportunity to address us on whether sanctions were appropriate, and also, frankly, as an expression to the bar that there are times when one can cross the line, and it was our measured judgment that you had done so in this case. So, as we had indicated in our earlier opinion in this matter, we are here to consider solely the issue of whether sanctions should be imposed on you for filing what we think is clearly a legally erroneous as well as frivolous motion for rehearing. So with those comments, I'll turn the floor over to you.
Thank you, Your Honor. And I apologize for that particular phrase. That was uncalled for. I actually wasn't even thinking at the time about how the court would take it. But I'm going to be 64 this year. I've been practicing law for 36 years. I have tried very hard to be honest, to have integrity and honor in my pursuit of my profession. I'm unemployed. Unemployed. I'm living on Social Security and unemployment and retirement benefits. So my first comment would be that I think any financial, I'm trying to put 3 people through school at the same time, any financial punishment would probably be disproportionate. I've got plenty of time if you want me to do community service or whatever, but I would hope that once you understand my frame of mind and what I was trying to do in this matter, that you would truly understand it. And as an alternative to the community service, if you want my resignation from the Florida Bar, I will gladly tender it to you. I've come to that point in my career where I'm not using it anyway, and this case in particular, and that's why this motion sounded like it did, this case in particular has been a thorn in my side for over 6 years now. I picked this case up. MARION, I was representing her as a plaintiff. She's sitting back here. And I want to tell you, there's one little vignette which is a microcosm of everything that happened in this case. We never even got the class certified after 6 years. And I've lost this case now 8 times. Once on a motion to dismiss and a rehearing, on motion for summary judgment and a rehearing, both of them brought to you, lost it again, and lost the motions for rehearing. And my thinking in what I was writing was this: I know at least one of you, and know him to be a person of good moral and character, and I assume almost a non-rebuttable presumption that the other 2 are as well. I still do not believe that anyone could look at the facts of this case, a person of good moral character, and condone it or allow it to continue. These men stole money from the most vulnerable people they could find, people who are in need of pain clinics.
Sir, we're here to discuss not the merits of your case.
I understand. I'm getting
We're here, and I appreciate the fact that you feel very passionately and zealously about this matter.
Right.
But there are still bounds that one should not cross. And when you write in your motion for rehearing, your contention that the adverse parties ran a con, and now the court seems to be saying this is okay in the 5th District. when you say that, please tell me that conspiracy to commit larceny by trick is not allowed in the 5th District.
Yes, sir.
Those things are both disrespectful and frankly just incorrect.
I did
That's the
not,
reason that we have asked you to come before you here today, not to replead the merits of your case.
right. I really wasn't trying to do that. I would be here for hours if I tried to do that.
You were trying to tell us what your frame of mind was?
Exactly, because I think intent in this matter, you know, what you can and should say, I think, has two qualifying characteristics. The importance of the case. I noticed in Judge Torpey's case, what was it, Ageron or something like that, of Aberon. It was a minuscule matter in which the plaintiff's lawyer went completely off the tracks. This was a matter, I thought, of great public importance. These people had cheated hundreds of the most vulnerable citizens in Seminole County, stolen hundreds of thousands of dollars, and I thought that justice demanded that I do this. I've not made a penny.
Do you understand this basic principle that when your complaint is dismissed for failure to state a cause of action, that we don't look at extrinsic facts?
Oh, sure.
We look at what you pled in the complaint.
4 corners.
4 corners.
Right.
Okay, so you're stuck with that. I read your complaint over again last night. I've read it several times, and I read it before you filed your motion for rehearing. And you're wanting to talk about a lot of facts that aren't in the complaint, sir. And this court is going to stay laser focused on what's in the complaint, because that's our responsibility, is to determine whether you actually stated a cause of action within the 4 corners.
I understand that.
And your motion for rehearing was almost entirely, extrinsic facts, and you're talking about extrinsic facts today, and we don't think that's proper.
It wouldn't be in the initial argument, but what Judge Jacobus said was
Wouldn't have
correct.
been in the initial brief, it wouldn't have been in the reply brief, and it certainly isn't appropriate in a motion for rehearing. Now, I see what you're saying. You want to give us all this factual backdrop to explain to us what your mindset was.
Right.
I can tell what your mindset was by reading the motion for rehearing. You were mad, and believe me when I say this,
Yes.
You're not the first lawyer that didn't like one of our rulings.
Oh, I'm sure.
Okay, we see a lot of these things.
But what I'm trying to tell you is I think
Pretty much 50%.
Pardon me?
Yeah,
Pretty much 50%.
But we're lucky if we can get 50%.
What I'm trying to explain to you is not the case again. I've lost that 8 times. I don't think I'm ever going to win it. Although I've won it against the corporation. Judge Sibbons finally, there's an order in the record, he finally entered a summary judgment against these people. But that's neither here nor there. Because I think if I can explain my mindset there, I think first it's a case of great importance. And frankly, second, even based upon the 4 corners of the complaint, it's clear. It's clear what they did. They set up, and it was a con. And I don't know any other word to use for it. They would get people in there and take their insurance information like they were going to bill them like anybody else. Yes, sir.
You're just re-arguing the case. And what I want to focus on
Okay.
is, do you concede that the language used and the writing used in your motion for rehearing was improper?
Yes, sir.
Do you also agree that it cited no fact, made no record reference, and cited no case that we overlooked? You made mention of one case, and I assume that you think that by PCAing the case that we had overlooked it. But with that one exception, do you agree that you cited nowhere in the record that we overlooked or misinterpreted anything?
I think what I was trying to explain was that the only possible explanation I could find, this case was dismissed without opinion, it was PCA'd without opinion. I have no idea why the case doesn't state a cause of action. The only explanation I could come to, and my mind is like one of those IBM computer cards that the light shines through it, and I'm kind of lockstep. I know you're a moral individual. I know what they did was immoral. And whether it was a larceny by trick or interference with an advantageous business relationship or however you want to phrase it, what they did was wrong. And that's why I was I was screaming, not at the court, of course, but screaming in agony.
Let's come back to the issue before us today. Is there any reason that the court should not impose sanctions? You expressed some reason as to what those sanctions should be. But do you agree or disagree that given the circumstances of the case that sanctions are appropriate?
I think I should be and am being reprimanded.
And so I take it by that you agree that sanctions are appropriate, and your contention would be that coming before the court for the reprimand is sufficient.
Under the circumstances, I would think so, Your Honor, because I'm probably going to quit the practice of law soon, and whether you accept my resignation or not.
Well, that's really a matter for the Florida bar, not for us.
I understand. But yes, I'm dutifully humiliated, and I've never been to one of these before. My record is clean. You probably checked it. And so I think 36 years ought to buy me something.
Do you have anything else that you'd like to tell us?
Could I tell my vignette?
If it's relevant to the issue of sanctions, yes.
Just very quickly, we filed on behalf of Marion first. Then we filed a Collection Practices Act case because one of these individuals had called behind my back to try to collect the payment. Marie's in tears. And in the course of that, we mediated it, and they gave up their claim of lien on my escrow account, which they had, and that's the basis of this complaint. 4 years later, with different lawyers, they decided our case had been settled when they settled the Consumer Collection Practices Act case, and sought to pierce the confidentiality of that case, of the mediation, in order for one of their people to testify, somebody who had already seen commit perjury twice. And in the course of that, they got up in front of a courtroom, in front of a judge in Seminole County, and said that this whole case was based upon the fact that Marion was trying to defraud these people out of $2,400. Marion was a nun. My tongue would have fallen off before I could have said something like that. I was sitting in that courtroom wishing I were anywhere but there and doing anything but practicing law.
All right, sir.
Thank you.
Thank you very much.
Thank you.
Court will be in recess.